Okay, so today we are building on the last lecture in terms of thinking about our lease license distinctions. So just growing that outwards in terms of how to address a problem question that pertains to when you see someone on land and how they are affixed or attached through a lease, what that agreement or document looks like, and then if it's framed differently, um, whether there's some form of malice or something being done to try and minimize their attachment or hold in the land by referring to it as a license. So we will look at that together. So we need to just go through those characteristics of a lease again very briefly and make sure that we can explore those and know which ones are integral. Identify how we would look at those characteristics and prove them or disprove them. Considering how objectively this is approached by the courts, so the courts on the outside looking in as what would be reasonable to assume, and not drilling down necessarily into the subjectivity of each case. Thinking about when there would be exceptional circumstances as to there never being a lease. So we have certain situations where people are within land in return for consideration of some form, and that still doesn't translate into a tenancy. So we can look at those as well. Give out some examples so that you can see what this might look like, and obviously preparing you for the seminar that's coming next week. And then, as ever, just recapping that stuff that we've been doing so far together each week, the status protection of the lease. So how would it be recognised in law and equity, pieces of paper, and also registration. And thinking about how to get rid of somebody, obviously, as well. So how does the lease come to an end? So the characteristics of a lease that we've looked at previously. The key one that we're going to focus on most in this lecture will be exclusivity of possession. So this notion that the tenant can exclude the world at large, including the landlord, is quite key. When you're looking at a term of years absolute, that's the absolute nature of their hold, is that they possess it to the exclusion of all others. So we will look at that one. Certainty of term, in contrast, is quite easy to articulate. We're looking for that term of years to be clearly identifiable and articulated. So we looked at Lace and Chandler as being for the duration of the war, and that not being sufficiently definite. So we would need dates, timeline, and a way of articulating that term of years with specific times in mind. Rent, as previously stated, is discussed in Section 205 of the Law of Property Act 1925. There is mention of rent in Section 205. The waters were slightly muddied in Street and Manford, which then seemed to indicate that we would need a rent. And this was clarified in Skipton Building Society in Clayton, where it said that a rent is indicative, but obviously there are other situations where people will be paying money to be on land, and that does not necessarily translate to being a lease, so it's not completely conclusive. So of the two that remain there, the last two, the certainty of term and the rent, quite easy to identify whether there's a term that is specific, quite easy to identify whether rent is being paid, but then it's not completely vital. So of the three characteristics of a lease, the one that we're left with the most problems and analysis requirement would be exclusivity of possession. So that's what we're going to look at together. So Exclusivity of possession is the key one. It's the main one that we have to articulate and find. We also are thinking about this binding relationship between the two parties as any form of legal relationship. So, same as any form of contract, we would have to have an intention to create that legal relationship. It cannot be purely the intention to contract, however, because we're contracting all the time on land. It has to be the intention to create a landlord and tenant legal relationship, not just one of different contracting parties. So we'll look at that together as well. Exceptional circumstances, so we'll look at the types of situations where there can never be a lease, and that's quite easy then to look at certain situations where you know there will not be a landlord and tenant relationship. And again, it usually is because there's some form of negation of that intention to create a legal relationship. They're there in some other capacity. But most importantly, when we're looking at exclusivity of possession, we're thinking about it objectively. So we'll look at how the courts have objectively viewed this. There are a number of cases that are in your lecture handouts that I haven't put up on the slides today, but I will discuss. And I want you to kind of go back to that thicker document and do the reading that's involved within that as well, please, before we go to seminar next week. So in Street and Mountford, we have a definition of exclusive possession provided. We have a definition given by Lord Templeman that the tenant possessing exclusive possession is able to exercise the rights of an owner of land. A tenant armed with exclusive possession can keep out strangers and also keep out the landlord. So Lord Templeman's quite clear in this that one of the key aspects of the absolute nature of a term of years is this notion of exclusivity, keeping out the world at large, inclusive of the landlord. And this was a key case, the key case really in this area, where Mrs. Mountford entered into a license agreement. She was going to take rooms from Mr. Street in return for what was referred to as a license fee in that document. She wrote away her rights under the Rent Act and said that she was happy to not be bound by it. The Rent Act, which applied to leases, would have allowed her more protection as regards rent increases and security of tenure. So she wrote away those rights under her tenancy. It was referred to as a license arrangement. Oh, sorry. And she was in payment of a license fee. So those are some of the ways in which in Street and Mountford we can see different language usage. We don't have reference to a lease or a tenancy. We have reference to a license arrangement. We don't have reference to payment of rent. We have a license fee. Important to recognise in this case that Street was a lawyer and Mrs. Mountford was one of these people who's coming to look for lodgings, fallen on hard times, needs to take a room. So they're very different bargaining power there, very different standing really in the eyes of the law in terms of legal knowledge and authority or expertise in how any of this works. So one of the first things we're getting in Street and Mountford is this articulation of what she should have or what a tenant should have in possessing exclusivity is this notion of the rights as if they are the owner to exclude all others. A simplistic way of looking at it would be to look at what happens in a case like Appet and Parncliffe, where we have lots of different occupied rooms within the one house and potentially shared bathroom facilities. So this is a lodging house or some form of kind of house of multiple occupancy. They didn't have to give any notice if they didn't want to be bound by the agreement anymore. The owner retained an ability to enter the rooms, and there were rules regarding guests who could come and who could go. So quite an old-fashioned dwelling house, usually used for people who were kind of in tightened circumstances before they got married, or maybe post-marriage breakup, etc. So these places where people could stay in different times when it was expected that in order to hold your own property, it would be in some form of marriage. Interesting to recognise, however, in this case that it actually suited the claimant for them to not be a tenant. This was in relation to items of property that had been stolen from her room. And the action is regarding her identity as a claimant. If she'd been a tenant, it would have been her own responsibility. She would have had her own lock. She would have had her own exclusive possession that would keep the world out, and her responsibility to keep it that way. But as a licensee, there was reasonable care owed towards her from the property owner. So this one, there was held to be non-exclusive possession of the room. She didn't have that full control that we would recognise within an exclusive possession of a tenancy. The proprietary right element, therefore, is missing. She's not a tenant, and there would be a licensee licensor agreement instead. Therefore, there was a duty of care towards her to keep her safe and her property safe. So sometimes when we're looking at these cases, we can see the law trying to operate in a fair way. In Street and Mountford, when we revisit it, we will see that there was a recognition of the different bargaining powers of the parties. Here we have a situation where actually it's in their interest to not be a tenant, and that was found in that way. So it's quite interesting to look at who our claimant is at times. Sorry, allergies hitting in and I'm really bunged up. So we have this phrase from Lord Templeman that I want to just explore for a moment and take us on a side step and come back to Street and Mountford. In Street and Mountford, Lord Templeman says tenancy requires exclusive possession. So in order to be a tenant, you have to have exclusive possession. However, exclusive possession alone is not enough to become a tenant. And we'll look at that now in a moment when we look at these exceptions to when somebody might be able to be a tenant, because they have got exclusive possession. They may have their own key. They may be able to keep the world at large out. There may not be no rules as to who comes and who goes, or whether they stay or leave. But they will still never ever be a tenant. So we will look at that together. What that means for us is when we're looking at how somebody behaves in land, we're thinking about how exclusive their possession is. If they have exclusive possession, they could be a tenant. However, there are situations where their exclusive possession alone does not make them a tenant. So what we need as well, in addition to their exclusivity of possession, we need for there to have been an intention to create that legal relationship. We need them to want to and intend to form the bound of landlord and tenant, and not just any other form of contractual relationship that might tie them together. So a lease is a form of contract. It's a binding relationship between the two parties, but their intention to create has to be the intention to create a landlord and tenant relationship. So they have to be intended to be bound by that relationship itself, otherwise it could only be permissive or be a license. And we see that in these cases where these people had exclusivity of possession, like in the previous slide, but that did not make them a tenant. So in Foster and Robinson, we have a farm worker who was allowed to live rent-free in the cottage that he had used while he was an employee. once he'd retired. So he's retired from being a farm worker and he's allowed to remain in the cottage that he had had during his employment, rent free. Now it's fairly obvious that that is not intended to create a landlord and tenant relationship. That's an act of generosity or kindness, and there's no intention there to be bound as a landlord to that party. So we can see that somebody like that might have exclusivity of possession, they might have their own key, they might be able to keep the landlord out, they may not have any rules as to who comes and goes, but they are not a tenant. They don't therefore become a tenant just because they have exclusive possession. Errington and Errington is about a young married couple, and they were allowed to stay in the house that had belonged to the husband of the married couple's father. So, again, another act of kindness, being allowed to stay somewhere after a certain time period, no intention, therefore, to be bound by them as a landlord would. So that exclusivity of possession of that house did not create a landlord and tenant relationship. Marcroft Wagons Anne Smith is the daughter of a former tenant also who was allowed to remain in property after the tenant's death. So all three of these cases show an amount of exclusive possession over the property that they're within. But in all three cases, we can only find that there's permission to be there. There's only a license, as there was no intention to create a legal relationship of landlord and tenant between the parties. So in all of those cases, this is discussed by Lord Denning and Ficini and Bryson, in all of those cases we can see that there was exclusivity of possession, but where the occupier has been held to be a licensee, even with that exclusivity of possession, there's usually been something like a family arrangement, something being done out of friendship or kindness that would negate the intention to create a tenancy. And we can see that in other forms of contract as well. Offering to give someone a lift to the station doesn't create, some form of taxi contract. So we're definitely looking for an intention to be bound as landlord and tenant. So I told you that there would be exceptional circumstances as to when people would never ever be able to become tenants. So we can see these situations where people are in occupational possession of property, but that does not mean that they then become tenants at any stage. Obviously, with service occupancy, we would have somebody who is occupying property in the commission of a service. So that's usually some form of employment where they're required to be on site. So that could be, caregivers, nursing staff, caretakers, ground workers, sometimes security personnel. So we've got these situations where somebody is required to live on site as part of their employment. That relationship is one of a employer and employee. That's the contract that they have. That's the intention to create a legal relationship that they have. They do not intend to become landlord and tenant. So therefore, in these exceptional circumstances of a service occupancy, somebody will never ever be viewed as a tenant in that regard. They will be there under a contractual license as part of their employment and subject to the usual kinds of revocation that a contractual license would have. Trespassers, obviously you wouldn't think of trespassers as becoming tenants, but we do have these situations where people are on land like squatters and can claim the land if they've been there for a certain period of time, but that would be their claim. Their claim would be through adverse possession as squatters. not as tenants. So they don't, again, have the intention to become a landlord and tenant. Their intention is to stay on the land and to try and take it if they can. We have people who are lodging in others' houses or who are paying to be in some form of residential care or private schooling. Any form of residence like that where there is some form of payment for board in a place will not equate to being a landlord-tenant relationship. It's a different form of consumer contract or a different form of hold of land. So the ability to stay somewhere in return for money in these situations where people are lodgers or people are providing for some form of care or education for themselves, they will not become tenants. We've had situations also where people buying have moved in and the paperwork hasn't gone through, and they've argued that they have some sort of hold in the land as some form of tenancy that they could pay for or could be seen to have a hold in the land as a tenant, and that's not true either. So those are other exceptional circumstances where there would never be seen to be a landlord and tenant relationship. So just to give you an example of what one of those looks like, with service occupancy, Norris and Checksfield, we have a coach driver who was living in a bungalow near the coach depot. So he had to be able to get to the depot in order to run early coach parties. So we have the driver dismissed through his course of employment. He was let go. And his argument is that he would like to be able to stay in the bungalow as a tenant because he would have security of tenure as a tenant. But we can see that with this form of hold in land, the service occupancy, it was the occupancy or the exclusivity of possession was a condition of the employment, and the relationship was that of employer-employee. So we have the occupation of the bungalow as a condition of employment. We have got somebody with exclusivity of possession. We have got a contract between them and a legal relationship between them. There's no generosity or friendship there, but the result is that they still hold a license because they are just purely there through the commission of their employment. At the termination of that employment, they have to leave the land. Okay, so we have to look at what it is that the parties have said to each other whenever we're looking at any of these agreements. Obviously, for a term of years absolute, we're trying to recognise that there is an absolute hold in the land, so that exclusivity of possession is partly what we're looking for. We're also looking for certainty of term, so we're looking for that term of years. But then we're also, on top of that, thinking about what the agreement states in relation to the parties and their relationship, because we're trying to find that intention to create that legal relationship of landlord and tenant. It should be fairly obvious by now that in most cases, apart from in the APA situation, if it's a license, it's going to be more beneficial to the person who has given the license or the permission to be on the land. Arguably, they don't want to be a landlord because that gives usually a higher level of protection to the person they've given the permission to and more of a hold over the land. So it would be in their interest to not become a landlord and have to allow someone to stay there, to allow somebody protection against rent increases, to be bound by them wanting maintenance and repair requirements. So we usually look at what they've referred to themselves as. Is there a mention of the agreement stating different words, such as license fee, license agreement, licensor, licensee, or is it set out like a lease agreement? What about where there is an agreement between the parties but it doesn't state how they should hold? Should the courts subjectively put themselves in the shoes of each situation, or is there a more objective way of looking at it? And it's viewed as an objective standard, it's viewed as a reasonable approach. However, we can look at the cases and see that on a case-by-case basis, they are also thinking about the bargaining power between the parties involved. We'll look at that. So the courts consider an objective approach in the case of Ficini. Ficini relates to a license agreement, and the courts looked at the labels attached by the parties, but viewed that the relationship between the parties was indicative of a landlord and tenant relationship instead. So we can see that there is this hybrid really of subjectivity going on, where they're looking at the relationship between those specific parties and their kind of standing, their power position between them. But what they're saying is it's objectively looking at whether a reasonable person would determine them to be a landlord and tenant, no matter what they've referred to themselves as. So they'll look at the rights and they'll look at the relationship between the parties, but they'll look at objectively then how, from the outside looking in, that would seem to be either a landlord and tenant or some lesser hold in the land. And we can tell that they're doing that when we look at cases like National Car Parks and Trinity Developments. In NCP and Trinity, we have a license agreement given to the NCP to manage the car parks. We have the developers, Trinity Developments, giving a license agreement, that's what it's referred to NCP to run the car park. The term was annual, so it ran from year to year, and it can be terminated by either party on 3 months. So we've already seen in Ficini and Bryson, it doesn't matter what they relate to themselves as. We'll look at the way in which they're holding their rights and relations together. The developer kept back 40 parking spaces for themselves within the car park itself. So the car park was not completely exclusively held by NCP. The developer kept back 40 spaces. The developer then serves notice, and NCP claim it's ineffective as the agreement was more like a tenancy and there should be more security. The courts in this situation said yes, the substance of an agreement is more important than the form, but here there was no tenancy as the developer had retained the right to enter and kept an amount of control, so that exclusive possession wasn't there for NCP. As well as that, the parties were seen to be equal in bargaining power. We're not talking about the difference between a lawyer and a woman who's fallen on hard times here. We're talking about two commercial entities with their own bargaining power and their own legal advisors behind them. So here it was deemed to not be a tenancy, that NCP would have known what it was that they were signing, the nature of the agreement, the name of the agreement, and would be bound by that notice period and couldn't claim to have been duped or to be bamboozled in some way into signing up for the wrong thing. So the objectivity that we're referring to in Street and Melnford is referred to by Lord Templeman as the manufacture of a 5-pronged implement for manual digging results in a fork, even if the manufacturer insists that they've made a spade. I think this is the reverse of calling a spade a spade. I think they're trying to say call a fork a fork. But in Street and Mountford, we have Lord Templeman recognising that it would be in the landlord's interest to refer to this document and arrangement as something else, and therefore benefiting from having less of a hold from them to that party. So as I've already said, in Street and Mountford we have Mr. Street, the lawyer, Mrs. Mountford coming to rent a room. The agreement is set out as a licence. It's referred to as a licence fee. The intentions were expressed as a licence. She negated her rights under the Rent Act 1977. However, the courts held that it would be a lease in that case. And I think it's important to identify that it's about fairness, it's about looking at the bargaining powers, and it's about not allowing people to dupe us into escaping from their landlord-tenant responsibilities by trying to dress it up as something else. So the cases that I've referred to in your handout, you've got Aslan and Murphy in 1990, where the landlord retains a key. It does not necessarily mean there is no exclusive possession. My landlord has a key. They can come in and do inspections if I'm not here. That doesn't mean that I don't have exclusivity of possession, and it doesn't mean that they're not my landlord. So sometimes people will try and do these things, say, oh no, I have a key, or I've put some rules in, or I've called it a license. And we can see that in Antoniades and Villiers. We can also see AG Securities and Vaughan. So you've got three cases there in 1990, Aslan and Murphy, AG Securities and Vaughan, and Antoniades and Villiers, all supporting this articulation in Street and Mountford, that it doesn't matter what you call it. It doesn't matter what games you try and play about putting rules on the house or keeping keys, that we are going to look at how you behave, and if on the outside looking in we think you're behaving like a landlord and a tenant, that's what you'll be viewed as. So when we're thinking about a tenancy, yes, we're looking for a certain term of years and we're looking to see if there's rent, but we're primarily focused on exclusivity of possession. Do they have the ability to exclude the world at large? Did they intend to be landlord and tenant towards each other? Did they intend to have that type of relationship, or was there some form of generosity, kindness, or family? Are there exceptional circumstances, such as service occupancies or residential homes, that would mean that they're never going to be landlord and tenant? And then we look at the agreement itself. We look at what those parties have said to each other and objectively view whether that's true. We objectively view whether they are trying to be tricksy in some way and negate their responsibilities as landlord towards their tenant. So we have to have exclusive possession for there to be a lease. We have to intend for that legal relationship to be made between the person granting the lease and the person who has been granted it in relation to a lease and a landlord-tenant relationship. We would look at exceptional circumstances, and we don't necessarily care what they thought whenever they were drafting or agreeing to it. We look objectively to see whether on the outside looking in, it's reasonable to assume that they've behaved like landlord and tenant towards each other. Just some examples to work through there. I'm going to leave them with you and come back to them in the seminar because you've got some similar ones. But if you're looking through these, please look through them and think about things like lodging, things like friendship, sorry, service occupancies, other forms of agreement where things are sorry, stipulated to be one thing but are actually another. So you've got some examples there. I'm fairly aware of what kind of time is against us, so we can work through those. I'm aware time is against us, and I'm going to have a sneezing fit for about 10 minutes. So you can work through those. As regards status, we've already started to look at that in registered land, understanding that there is a difference between a legal lease and an equitable one. A legal lease needing a grant under section 52, so we would have an express grant through a lease, except for a short-term lease under 3 years under section 54(2). We have an implied grant where the tenant has reached the end of their grant and bless me, it rolls. So that's known as a periodic tenancy. So if a tenant came to the end of their 7-year lease, it would carry on rolling in terms of the period at which they paid rent. So if it's a monthly periodic tenancy or an annual periodic tenancy, it will be implied that that legal lease still rolls. Equitable leases would be where there's no deed, or where there should have been a deed and it's not been conducted correctly under section 1 of the Law of Property Miscellaneous Provisions Act 1989. So we've already covered that stuff together. For registered land, we know that a legal lease over 7 years has to be registered under section 27 of the Land Registration Act 2002. Less than 7 years, it would be an overriding interest. We know that an overriding interest applies to equitable leases too, but they could have been entered as a notice under section 32. They could also be entered if they were a legal lease between 3 and 7 years. So we've covered that stuff already. Final slide for me to get through before sneezing and exploding. Okay, so how to end a lease. The lease can end through complete expiration. We can have the lease come to a natural end because it has expired. So we would look at then the fact that the tenant might have the right to renew, or that might just be it. There might be a notice clause put into the lease that allows them to give a notice as to when either party could terminate. Other than that, for a fixed term lease, you would have a periodic situation rolling. So like I said, if it's a 2-year lease and it comes to an end and no one has renewed it, it will become a periodic tenancy, usually rolling month to month if that's how the rent is paid. Surrender, so it's possible for the tenant to surrender the lease back to the landlord if they go, look, I've fallen on hard times, there's just no way I'm going to be able to keep up with this. There may be some ability for the landlord to be lenient and find another tenant, so it may be possible for the tenant to surrender their lease. Merger is usually in a situation where the tenant becomes the owner. So if the tenant is staying somewhere where they then end up buying, the lease obviously comes to an end because the estates merge. The term of years absolute merges then into the fee simple absolute in possession, and there is no tenancy anymore. Forfeiture is usually where something has broken down and the lease becomes forfeit in some way at either end. We looked at that very briefly when we looked at covenants in the last lecture. There are a number of promises made between the landlord and tenant, the most important one being to pay the rent, and if any aspect of those promises are forfeit, then the lease could be seen as being null and void. Okie dokie, so what I wanted to do was just recap those characteristics of a lease, be able to look at them and know which the key ones are, and really the key one would be an objective approach to exclusive possession and the key cases around that. So I really want you to look at those other cases in the handout as well, because I will expect you to be able to talk to me about Aslan and Murphy, Antoniades and Villiers, please. So we've got exceptional circumstances, as do when there will never be a lease, such as service occupancies and residential homes. I've given you some examples to look at. I'd like us to work through those in the seminars together, and you've got similar ones coming up in your seminar prep for next week. And then we've looked at stuff we already know about, the status of the lease in terms of law and equity, how it should be protected at land registry, and how we could get rid of it, or how a lease could technically be ended or terminated. So thank you very much for listening, and sorry for my issues today.